Hi, I'm Tulsa divorce attorney Palmer Johnson, and welcome to my video series where I answer frequently asked questions I get from clients about family law issues. And today I'm going to be specifically talking about ways to attack a prenuptial agreement and what could invalidate a prenuptial agreement. And they're typically going to be one of two things. Either something has to do with the actual way that the agreement was entered into, or a provision itself is invalid, are going to be the two ways that you would attack a prenuptial agreement. So the first thing I'm going to talk about is entry of the agreement. There a lack of fair disclosure. If the other side didn't disclose all of their assets when the agreement was entered into, then potentially you'd be raising issues of fraud. You didn't possess the information that you needed to be able to enter into the agreement. That would be a way that you could fundamentally attack the entire validity of the document. Duress would be another way that you could fundamentally attack the entire prenuptial agreement. Duress situation would be that you are provided with the document at the last minute and told that if you don't sign it, then the wedding is canceled. As a general rule, the actual contemplation or the cancellation of the marriage as a condition of signing the premarital agreement will almost always invalidate it. So it's something that people should be very careful about how they approach that issue, even on the front end of talking to their spouse about, or their attorneys talking to their spouse about entering into a prenuptial agreement. The other thing that you could have would be provisions that would just be facially invalid. There are just certain things that, while might be good for the parties to discuss prior to entry into marriage, such as division of duties, who's going to do what, things like this are not going to be enforceable provisions in a prenuptial agreement. You also can't provide for conjugal access to your spouse. In other words, you can't have a condition of the prenuptial agreement be that you have to engage in sexual intercourse with that person a certain number of times a week, for example. Those are going to be unenforceable provisions, and depending on exactly what strange provision could be included in a prenuptial agreement, it's possible it could invalidate the entire agreement. But typically, just because one provision on its face is invalid does not necessarily mean that the entire rest of the agreement is going to be unenforceable, absent one of these larger problematic issues such as fraud or duress. If you've got a prenuptial agreement and you have questions about your individual situation and how your rights might be affected, please reach out to me at moms.law and set up a low-cost consultation where I can specifically talk to you about your case and help ensure that your rights are protected and you've got the legal representation that you need in the event of your divorce or enforcing your prenuptial agreement.